Okay, well, welcome back, everyone. Thank you for joining us today. We hope you enjoyed the first panel on Loper Bright and found it useful to your work. Our second panel will discuss SEC versus Jarkesy, another one of the big decisions in administrative law that the Supreme Court just handed down. I won't repeat my opening remarks from the first panel, Loper Bright, except to say thank you to everyone, to our moderator, to our distinguished group of expert panelists, and to all of the ACA staff who worked so hard to make this entire forum come to pass. The moderator for this panel today, we're very lucky to have him, is Matthew Wiener. Matt was the executive director, the vice chair, and the acting chair of ACUS. He currently serves ACUS as both a special counsel and a consultant advisor. Matt is also a lecturer at the University of Pennsylvania, Carey School of Law. Matt, thanks again. Over to you.
Thanks very much, Andy. I think I can speak for all the panelists in thanking you for inviting us, you and the ACA staff for inviting us to participate in this panel. And thank you, of course, to all the members of the audience for joining us today. We'll proceed as follows. I'll start with very brief introductions, and then I will provide a very, very brief overview of Jarkesy, and then our panelists, of course, can expand on my remarks, and then we'll turn to a moderated discussion, and then we'll try to save some time at the end for questions and answers. So let me start with introductions. All of the panelists' affiliations were on the screen, their names and affiliations. I'll just introduce them real briefly. Jen Dickey of the U.S. Chamber Litigation Center, Chris Walker of the University of Michigan Law School, and Jeff Lubbers of American University, Washington College of Law. They hold diverse and very well-informed perspectives. All are ACUS members, two non-voting members, and one voting member. I think Jen is the only voting member of the group. She's now serving as a public member. And let me just point out two biographical facts with respect to Jeff and Chris that bear on our panel today. First, Jeff was the co-author with, among others, Paul Verkyle and Richard Pierce, both ACUS members, Paul the former chair, of a 1992 book-length ACUS report titled The Federal Administrative Judiciary, which Justice Sotomayor, in dissent in Jarkesy, cited in support of her observation that over the last 5 decades, since the early 1970s, Congress has enacted, and I quote now, countless statutes authorizing agencies to impose administrative remedies administratively. And in Chris's case, I'll just point out that he's the co-author with David Zering and Wharton of a pre-Jarkesy article that appeared earlier this year, I think in the Ohio State Law Journal, if I'm correct, proposing that at least in certain agency proceedings, respondents should be able to, or can be able, or should be able to decide whether to proceed before the agency in an administrative adjudication, or instead to remove the adjudication to a federal court, much like in some cases a litigant can remove a state court action to federal court. So let me just start now with a very brief overview of Jarkesy. I'm going to go quickly, and again, I'm going to let our panelists fill in any gaps and develop any aspects of the case that they wish to in response to the questions that I'll turn to in a few minutes. So Jarkesy, an important background of the case is that at least after the Dodd-Frank legislation in 2010, the SEC could seek civil penalties for fraud prescribed by several of the securities laws that the SEC administers in one of two forums. Before itself, so to speak, in a formal APA administrative proceeding, or what some people call in-house, or alternatively in federal court. One of the things we'll discuss, no doubt we'll discuss when we get to the discussion, is that some agencies do have this forum choice, like the SEC, and others don't. They can only proceed administratively, and we'll talk about the consequences of that very shortly. The SEC's reliance on this in-house adjudication system has received a lot of press scrutiny, especially in Wall Street Journal, among other publications, and also received criticism from the business community, business groups, and other groups who have complained about the alleged high win rates that the SEC enjoys in administrative proceedings as opposed to court proceedings. So let me turn very briefly to the facts of Jarkesy. In an in-house adjudication that went on for many years, the SEC imposed significant monetary penalties against Mr. Jarkesy and his affiliated company for securities fraud. And I'll just refer to the two respondents in Jarkesy simply as Jarkesy. Jarkesy sought review of the SEC's decision in the Fifth Circuit, and the Fifth Circuit held the adjudication unconstitutional on 3 grounds, and the SEC set aside the Fifth Circuit's judgment on 2 of the grounds. The court addressed the Supreme Court affirmed the Fifth Circuit's judgment by a 6-3 vote. Chief Justice Roberts wrote for the court. Justice Gorsuch, joined by Justice Thomas, wrote a concurring opinion, and Justice Sotomayor, joined by Justices Kagan and Jackson, dissented. The court addressed only one of the 3 issues on which it had granted cert, and that issue was whether the 7th Amendment entitles a defendant to a jury trial in federal court when the SEC seeks civil penalties against the defendant for securities fraud. And I'm there quoting from the court. The 7th Amendment, just by way of refresher, is provides, subject to a now meaningless case and controversy requirement. The 7th Amendment guarantees a jury trial in federal court in any suit at common law. The court answered the 7th Amendment question, yes, that the 7th Amendment entitled to Mr. Jarkesy to a jury trial in federal court. And in answering that question, the court undertook 2 inquiries. The first inquiry is just required by the text of the 7th Amendment. And the question there is an SEC action for securities fraud a suit at common law within the meaning of the 7th Amendment? And that in turn raised the question whether the SEC's action was equitable or legal. And here we get into some, what for some at least, and probably many administrative lawyers, are arcane distinctions. They're distinctions that are important to, among others, people who work in the remedies area. But let me just go through them real quickly. So is the SEC action a suit at common law within the meaning of the 7th Amendment? Yes. And so the court, in reaching that conclusion, the court looked both to the remedy in the SEC action as well as the nature of the cause of action. The court said, perhaps in a departure from some recent Supreme Court case, the most recent Supreme Court case on the 7th Amendment, but in any event, the court said that characterizing the remedy was the most important question. And in fact, in this case, the characterization of the remedy as legal rather than equitable was, as the court put it, dispositive. So what the court concluded that with respect to the remedy, namely civil penalties, that it was legal rather than equitable under the court's precedents, since the objective of the remedy is punishment and deterrence. And the dissent did not take issue with that particular characterization of the remedy. Having concluded that the remedy was legal rather than equitable, the court then turned to the cause of action to ask whether it was legal or equitable. And the court concluded that it was legal because an SEC fraud action is closely analogous to a common law fraud action, even if the SEC didn't need to establish financial harm, as would be required in a common law fraud action. And as we can talk about maybe in a moment or two, the dissent did object to this conclusion about the closeness of the analogy between the common law fraud action and an SEC securities fraud action under the securities law. All right. The court, having concluded that the SEC action was a legal action within the Seventh Amendment, the court's work wasn't done. It had to undertake a second and I think more important inquiry. And here we get to the real crux of the disagreement between the majority and the dissent. The court had to ask the question whether the case fell within what's known as the public rights exception to the federal court's jurisdiction under Article 3 of the Constitution, which is the judiciary clause of the Constitution, with the result that Congress could assign civil penalties action to the SEC for adjudication, even though the SEC administrative proceeding wouldn't afford a right to a jury trial. And the court said, the court concluded that no, the SEC, this SEC claim here did not fall into the public rights exception or doctrine. What the court said in particular is it didn't fall into any of the historically recognized, that is, those recognized by the court's precedents, public rights exceptions. And we will talk about this, probably at length in a moment or two. The dissent contended that at very least, whatever the exact content of the public rights exception, it at very least includes any claim brought by the government in its, quote, sovereign capacity to enforce new statutorily created obligations. And I'll just say one more thing about the basis of the court's holding and its reasoning. Probably the biggest obstacle to the court's conclusion on the public rights exception question was a 1977 case called Atlas Roofing. And there the court rejected a Seventh Amendment challenge to an agency's adjudication of civil penalties under the Occupational Safety and Health Act. The court said with respect to Atlas Roofing that assuming it was still good law, the act that was at issue in Atlas Roofing, the OSH Act, unlike the securities laws, had no common law analog. That is that the occupational safety statute at issue in Atlas Roofing imposed an entirely new set of regulatory obligations governing the workforce. So that's my nutshell summary of Jarkesy and its Seventh Amendment holding. I'll just say this before we turn to our panelists, that our exclusive focus today will be on the Seventh Amendment questions that the case raised and its implications for agencies, principally other than the SEC. As I did mention, there were two other questions, or I hope I mentioned there were two other questions on which the court granted cert in Jarkesy. The court did not address either of those questions, and we won't either today. I will finally note with respect to Jarkesy that the SEC itself is probably no worse for the wear as a result of the decision, because as I mentioned, the SEC can always bring enforcement actions in federal court. And in fact, it's my understanding that at least in recent years, the SEC has resorted to federal court enforcement in civil penalties cases rather than proceeding in-house. So let's turn to the panelists now, and I'm just going to ask. What I'm going to do is I'm going to ask 5 or 6 somewhat open-ended questions here, and let the panelists run with them however they think is most appropriate. And hopefully we'll have some dialogue on these questions and disagreements among the panelists. I suspect we will. So the first question I just posed to the panel is, how significant of an impact will Jarkesy have beyond the SEC, and in particular on the authority of other agencies to impose civil penalties through administrative proceedings. And I have a feeling that this question will take us very quickly into a discussion of where the court has left the public rights doctrine or exception, if you prefer. And what I'd like to do, especially given Jeff's familiarity with ACUS's work on civil penalties and so forth, I'd like to turn to Jeff first, and then Chris, and then Jen on this first question. So let me turn it over to you, Jeff.
Well, thanks a lot, Matt. I'm very happy to be here. And I also want to mention that you just published a very good article about Jarkesy, and I'm going to try to send it to Matthew Glue so he can send it to everybody. Okay. Am I still muted?
No, you're good. I can hear you, at least for my part.
Okay. So I was just mentioning that you published a very good article in University of Pennsylvania's Regulatory Review on Jarkesy. So I'm going to try to send it to everybody. And I guess I'm going to start with a little history about how the Administrative Conference played such a big role in the creation of administrative adjudicated civil money penalties in the first place. I worked for ACUS from 1975 to 95. And when I joined in 75, I quickly learned that one of our most successful recommendations was issued 3 years earlier, ACUS 72-6. And that recommendation recommended that Congress make more use of civil money penalties in general, and also use what is called the agency imposition model for doing so. And it was successful because Congress listened and did create numerous such statutes. But with Jarkesy, at least some and maybe all of these statutes are now vulnerable to constitutional challenge. And of course, unlike Loper-Bright, this was a constitutional decision. Now, this recommendation was based on a study that was done by a professor named Harvey Goldschmidt, who later became an SEC commissioner. And he really did the first broad survey of such penalties. And I'm going to put the citations to both the recommendation and the study in the chat as well. And part of the motivation for recommending more use of civil money penalties in the first place was that a lot of agencies only had sort of harsher all or nothing type penalties, such as license revocation proceedings or referring a case for criminal prosecution to DOJ. But the drawback was that most civil penalty statutes at the time, all but 4, required a trial de novo in federal district court. So this not only meant that the defendant could have a jury trial, it also meant that most agencies had to refer the case to the Department of Justice to persuade them to bring the case. And this meant that U.S. attorneys would have to do it. And many of them were not anxious to bring such cases because they had to learn a difficult area of regulatory law to do so, and possibly go after a company that employed a lot of people in their district, all for a penalty that was relatively small and flowed into the U.S. Treasury. So the result was that agencies settled 90% of the cases, according to the Goldschmidt report, and this resulted in a lack of deterrence and under enforcement. One interviewee in the report said unwise settlements are being made principally because, quote, the Department of Justice presents an immovable roadblock. We can't get our cases into court. And moreover, Goldschmidt pointed out that in cases of small penalties, the proceeding was too expensive for defendants to want to use as well. So this is all why Recommendation 72-6, which, by the way, was issued under the chairmanship of Antonin Scalia, I might add, proposed that the so-called agency imposition model, where respondents could have a formal APA hearing before an agency ALJ with review by the agency head and ultimately judicial review on the administrative record in the Federal Court of Appeals. So when ACUS studied civil penalties again in 7 years later, in the report for recommendation 79.3 on agency assessment and mitigation of such penalties, Professor Colin Diver was able to report that, quote, "It is today almost inconceivable that Congress would authorize a major administrative regulatory program without empowering the enforcing agency to impose civil money penalties as a sanction." He found that there were 348 statutory penalties enforced by 27 agencies, and 54 of those required the agency to hold a hearing before assessing the penalty, with 27 requiring a formal APA hearing. So that was up from 4 7 years earlier. He also found that the government had collected $52 million in 1977 compared to Goldschmidt's finding of $9.5 million in 72, although that compilation was a little bit incomplete. So the recommendation created, had some factors that the Congress should consider when deciding whether to have administrative imposition. One of them, I would acknowledge, is that penalties would be small, unlikely to exceed $5,000, which today would probably be, I don't know, $30,000. So that was the history of all this. And I think that now, Jarkesy is calling into question the constitutionality of a lot of these penalties. Now, it didn't overrule Atlas Roofing, so I guess we'll get into why Atlas Roofing, the penalty scheme there, was different from the fraud penalty scheme in the SEC, and which penalty statutes are on which side of that line. But I think I'll stop there and let the other panelists take over.
Let me just, before I turn over Chris, let me just mention, Jeff, one more ACUS recommendation, and it's a more recent one, 2000, I don't know, 18, 19, 17, somewhere thereabouts. ACUS issued a recommendation urging Congress to adjust civil penalties for inflation. I think it was called inflation adjustment. So that was ACUS's most recent engagement with the issue of civil penalties.
Which Congress did enact. There's a statute called the Inflation Adjustment Act.
Correct. And agencies do regularly report as required, I believe, in the Federal Register, their compliance efforts or their compliance actions with the Inflation Adjustment Act. Chris, let me turn to you. The impact of Jarkesy beyond the SEC, at least in civil penalties cases for now, and then we can broaden it in a moment.
Yeah, I mean, I would just start out by saying, in some ways, this is a very narrow opinion for the reasons that apparently we're not going to talk about, which is it only reached the first constitutional question, right? It didn't reach the Fifth Circuit's non-delegation holding, and it didn't reach the dual layer removal. My understanding, those in the Fifth Circuit, that's the law of the land still. The Supreme Court did not vacate those two parts of the Jarkesy decision, and so I would expect those to still play. Do you disagree with that, Matt?
No. What I wanted to say is, if we have time at the end, why don't we return to the ALJ removal issue, if there's some extra time?
But I mean, so in that sense, I think it's like a narrow decision. I think if the court had ruled on one of the other two grounds and found it unconstitutional, it would be a much broader decision. But reading the decision itself on the question, it's not a narrow opinion. I mean, I kind of hoped or thought or expected that the Supreme Court would say there's something really, really, really special about the SEC civil penalty provision that makes it so similar to common law fraud. And reading the decision, I just don't see much of a limiting principle here. I think the one limit is they don't expressly overrule Atlas Roofing, and that's probably it. And even Atlas Roofing, between the majority and the concurrence, it sure seems like they said it's barely hanging on just because it's a precedent and nothing more. And so I don't see a limit here. And maybe Jen or Jeff will disagree with me, but I see this as the only limit is stare decisis with Atlas Roofing. And so that'll be interesting to see how that plays out. Justice Sotomayor, I think, did a fantastic job of mapping out for regulated industries what to target next. I mean, her opinion really just kind of, in a lot of ways, invites and crystallizes the breadth of the majority opinion. At the end, listing the dozen or so agencies that have civil penalty provisions that are similar. And so I guess kind of my initial kind of reaction to it and the breadth of it will have in other agencies is that I think we're going to see litigation everywhere. challenging it, and I don't see stuff in the Supreme Court's decision that tries to cabin it at all to the SEC context.
Okay, thanks, Chris. Jen, let me talk to you. Let me turn to you on the implications of Jarkesy, at least for starters in the civil penalties context.
Sure. And just out of an abundance of caution, I think this probably applies to my co-panelists as well, but all views I express are my own, not those of my employer or my clients or former clients. I'm cautious by nature. So, but I do think that Jarkesy is a pretty significant decision. I think that the analysis on civil penalties, the fact that the dissent didn't disagree with the fact that these are legal in nature sends a pretty strong signal about the scope of sort of what the court currently views as legal for purposes of the Seventh Amendment. And then, of course, once you get into the public-private rights distinction, I think that analysis, it could be very significant. We'll have to see. We'll have to see where the lower courts take it. Right now, they had presented a case that the court at least thought looked a lot like common law fraud, but there's a lot more stuff out there that the federal agencies seek civil penalties on that is not the stuff of common law fraud, and how broadly the public-private rights distinction gets sort of fleshed out in the lower courts, I think is still a matter to be seen. I will note that the majority did sort of cabin off the other precedents besides Atlas Roofing is correct. That they mentioned Helvering, the IRS, administration to get penalties for underpayment of taxes, Murray's Lessee, Oceanic Steam. I mean, they didn't say that any of those were wrong. They expressly distinguished those, immigration, tariffs, those kinds of things, patents, we know they view as public rights. So we still have all of those cases on one side of the line, but I think there's a brave new world of litigation opening up about what's on the other side.
Let's talk more in a minute about what is on the other side when we talk about the public rights doctrine. I just want to move to a second question, and it's the sort of the subject of the short piece that I wrote that Jeff was kind enough to call to everyone's attention. And the basic question here is, what implications does Jarkesy have for administrative adjudication programs that won't be challenged under the Seventh Amendment because the claim can't be characterized as legal? It would be characterized instead as equitable. I'll give it an example in a moment, but it would be challenged instead, presumably just under on Article 3 grounds. When I say administrative adjudication programs that don't involve legal remedies, I'm talking about, of course, any number of adjudication programs that provide, just for lack of a better term, injunctive relief. An agency orders a company to cease and desist from some unfair business practice and so forth and so on. So let me just turn. Let me ask for your thoughts on that question. That is the implication of Jarkesy outside the context of cases involving civil penalties and perhaps other legal remedies. And in the first instance, let me just turn to Chris, and then we'll turn to Jeff. Excuse me, Chris, Jen, and Jeff will be the order on the second question here.
Yeah, I mean, this is the dynamic. I remember when I was trying to explain this case to my mom when it was argued, she was like, wait a minute, but can they just bar Jarkesy from the market entirely? And I was like, yeah, they can. And they're like, well, that's kind of weird. Civil penalties have to be in an Article 3 court before a jury, but even more drastic remedies like disgorgement or barring from the market wouldn't have to be. And I don't know. I'm curious what Jeff and Jen think. I don't think the court, I think the majority opinion very consciously doesn't try to wade into the Article 3 stuff when it comes to more equitable remedies, and that it really tries to kind of cabinet to just the jury right issue. Although candidly, as Justice Gorsuch notes in his concurrence, the two are really wrapped up together when it comes to the public rights, doctrine. But I do think the majority is trying to kind of stay that off for another day. And beyond that, I think, Matt, I want to flag my answers before about civil penalties. I do want to say, the vast majority of agency adjudications that are just dealing with public benefits I mean, those aren't going to be at all like implicated in my opinion. I think what we're talking about now is that middle ground where you have some sort of equitable relief in a private rights-ish type context, where you might have an Article 3 argument against it. But that's kind of my take, is I think the majority was very conscious of trying not to reach that issue.
But
But it
you
also
would
doesn't
agree-
close the door on it. So
You would agree that most agency adjudication is the constitutionality of most agency adjudication is going to does rest on the public rights doctrine under current modern doctrine, and the same public rights doctrine that the court dealt with in Jarkesy in the Seventh Amendment context comes into play in the context of any Article 3 and Article 3 challenge to adjudication, whether even if the remedy, well, even if the nature of the claim is equitable. So that the bottom line here is the key question that we need to walk away with, whether we cast these as Article 7 cases or Article 3 cases or Seventh Amendment cases, is does the case fall within the public rights exception? I'm wondering if, before we turn it over to Jen, if you want to say anything more about what the court did with the public rights exception. The Chief Justice, in his majority opinion, was very careful to say that we don't yet again attempt to define what the public rights doctrine means. The Chief Justice conceded that confusing precedents abound. I think that's a quotation. Do you have any sense as to where the public rights doctrine stands right now after Jarkesy? There are obviously some easy cases, an adjudication for Social Security disability benefits, veterans benefits. Those kind of cases obviously fall within the public rights exception. But do we have a sense after this case as to where the court stands on the public rights exception?
I mean, I'm curious if Jeff and Jen disagree. I mean, I view, I don't think the court moved the ball much beyond where we're at with oil states. That's kind of where on the public rights part. Maybe I'm just wrong on that, but I kind of think that I think the Chief Justice was very consciously trying to just focus on the Seventh Amendment issue.
Jen, what do you think on the public rights, on this question more generally, but the public rights exception in particular?
I probably disagree a little bit with Chris. I think that they did move the ball. I think that oil states can be read pretty significantly focused on the patent context. And here we see the court at least trying to set out a standard for the public-private rights distinction. First, they say it's like something that historically could have been determined exclusively by the legislature or the executive. Then they get into like the nature, what is the nature of the claim? Is it the subject of a suit that would have been at common law? And I think that's where they're going, which is a lot different from like patents or a one-off. We're just going to say patents since like 1899. We've said they're public rights, at least the issuance. We're going to carve off the rest, like they said in oil states. So I think they did move the ball, and I think they were conscious throughout that this was going to affect Article 3 adjudication. I think you see that from the dissent and the concurrence, and the majority is like kind of silent on it. They're not saying, oh yeah, we're doing this, like everybody noticed, but they are very well aware that that's what they're doing when they're deciding this Seventh Amendment question.
I just ask just a follow-up question based on your comment. Why was this case brought as a Seventh Amendment case at all, rather than an Article 3 case? And would it have made any difference? And that's sort of apropos of the general question I've asked here.
I mean, I've never spoken to Mr. Jarkesy, but I would assume that he thought that the Seventh Amendment in particular is more likely to have broader appeal to the justices. It sort of implicates some of the due process concerns that we've seen on the left and right. I feel like sometimes the structural concerns like Article 3 have been perceived as, maybe like more on the right versus the left, and the Seventh Amendment really is not that way. I mean, I think you see that when you see none of the justices disagreeing that this is legal in nature. And then I would also add, there's some interesting issues with waiver and consent that we can talk about a little bit later with respect to the Article 3 issue that I think are not present with a Seventh Amendment issue. It's pretty well decided that the Seventh Amendment is a waivable right. Article 3, I think this opinion, we'll talk about it later, but I think this opinion says that's not waivable.
And that's consistent with some of the current justices' prior statements in other cases.
Yeah, and we can talk about wellness and how this relates.
Jeff, let me turn to you, and in particular where we stand with the public rights exceptions, sort of across the board, not only in Seventh Amendment cases, but cases that would not be subject to the Seventh Amendment because the relief sought in particular is equitable.
I think I agree with Chris that they tried to stay away from that. I think just to respond to something that Jen said, this was not a due process case. There's never been a successful challenge to APA formal adjudication procedures under the due process clause. It's always been sort of held up as the sort of gold standard of procedural due process under cases like Matthews versus Eldridge. I mean, the formal APA procedures, which is what was being offered to Mr. Jarkesy in this case. So, why they chose Seventh Amendment over Article 3, I don't know. I think, there are a lot of precedents that go back on the Article 3 cases, things like not only oil states, but, Shore and Kroll versus Benson. And, so a lot of old cases that have said that it's okay within Article 3 for Congress to assign certain types of adjudications to the agencies. And that was a basis for Atlas Roofing. And when Justice Kagan was doing her questioning, she basically asked, why doesn't Atlas Roofing just decide this case? It's on all fours with Atlas Roofing, she was implying. And the court's answer to that was, well, Atlas Roofing, the OSHA Act scheme, was a self-consciously novel scheme. So even though some people argued, well, this kind of workplace violation can also be traced back to certain types of common law actions. But as opposed to the SEC fraud statute, which has a, quote, close relationship with a common law analog. Well, so that's the dividing line that the court talked about. But then they said that the remedy is all but dispositive. Well, that sounds like all civil penalty cases are suspect. Now, didn't apply to Atlas Roofing, but it would apply, it seems to me, just for another example. I haven't heard anybody bring up this statute, but there's a statute called the Program Fraud Civil Remedies Act, which was passed, I think, in the late 80s, early 90s, which allows any agency basically with an IG to go after people for fraudulent submissions to the agencies. They have to get DOJ's approval, but then they can bring an administrative enforcement action before the agency ALJ, review by the agency head, appeal to the courts. I mean, it's just like it's a fraud-based type of statute. So it seems to me that Jarkesy declared this statute, PIFCRA, to be unconstitutional, and probably 70 agencies have rules of practice for how to do these cases. So I think I'm not sure that answered your question, but it seems to me in benefits cases, I mean, first of all, the Supreme Court does not want to have all those benefit cases, the hundreds of thousands of benefits cases, end up in the federal Article 3 courts. They're going to do whatever they can to keep that from happening. So I think there was a long ago study by a commission headed up by Robert Bork, which was trying to get cases out of the federal courts and into the agencies.
And Bork, I believe actually Bork argued Jarkesy on behalf of the federal government. Let me if I could just turn back to Chris for a second here, and I'm going to turn back to you because you teach this stuff, or you have a case book that covers all these public rights issues, and the kind of cases that Jeff identified, the benefits cases. I don't think anybody questions that falls within the public rights category. Those are easy cases. But there could be some very difficult cases. And I think you would probably agree with me that these cases that you probably spend you may spend time on in class and certainly are reflected in your casebook are maddening to understand and maddening to teach. And you've got in some of these cases, Stern versus Marshall in 1989, a bankruptcy case, you've got these very broad formulations. And that was one written by the Chief Justice, by the way. It was dicta, the point I'm going to make here. But you've got some very broad formulations. I think in that, to the effect of a public right is anything that's involves a claim integral to a federal regulatory program that's derivative of a federal regulatory program. And the court in these prior cases has seemingly cut a pretty wide swath with the public rights doctrine. Those cases really aren't cited, or at least they're not discussed in Jarkesy. I mean, do you see like a serious retrenchment here on the public rights front, or do we really have, as I think Jen does, or do we really have to wait and see?
Yeah, I mean, I guess I think we have to wait and see. I don't read as much into the majority opinion as Jen does. I will say the Q&A is wild right now. If folks, I mean, we've got law professors, not that are kind of weighing in. I mean, I think one of the comments of the Q&A, like, it is interesting that Roberts does rely on Crowley v. Benson, which I still think is kind of the classic attempt to try to define public rights. But he cites some of the examples and not some of the other examples. But I think at the end of the day, the majority really just didn't want to go there. They wanted to, and I think Jeff said this to a degree. I mean, the Seventh Amendment area, even though we've all thought of them kind of moving lockstep together, I think Jarkesy's counsel was thinking quite creatively and saying, you know what, they don't need to move together. And there's a really, really kind of great public opinion argument about the importance of juries, and this isn't shifting power to courts, it's shifting power to the people, which I think Justice Sotomayor just completely missed in her dissent. And so I think it plays differently. And I think the Chief Justice ran with it. Jen disagreed with me, but I think that's what the Chief Justice did. And Justice Gorsuch doubled down on his kind of the Lawson hamburger, as Bill Funk mentions in the Q&A, kind of more Lawson hamburger approach of let's mix in a little due process with a little Article 3 and a little jury right. And we end up without any agency adjudication. And so I think that's kind of the dynamic here. So I'm still not willing to read a lot into the majority, into the tea leaves or into the actual opinion on what the majority is doing with the public rights doctrine.
Jen, anything further before we move on from the public rights doctrine? I assume you're probably somewhat enthusiastic about the what the court did with the public rights doctrine in terms with an eye towards future challenges to other adjudicative programs.
I mean, I'm a litigator for the Chamber of Commerce. I love to litigate against the government. This is great for us. We are looking forward to litigating these issues on behalf of our members. So
let me turn to the next question. I'm going to start with you on this. We're not going to ask you to disclose your litigation strategy or identify your, 10 most wanted and so forth and so on. But, as a practical matter, what types of adjudications at which agencies do you think we're going to see challenges in the wake of Jarkesy? And, and I'll just put another practical question on the table. You could answer this or not as you like. In what posture are these challenges likely to arise? Are they going to arise as defenses in adjudicative proceedings, or are they going to arise in the context of, collateral direct challenges in federal district courts of the sort that was basically green-lighted last turn in FTC versus Axon?
I think it depends a little bit on what the government does next in terms of, if we see a pause in administrative actions by some agencies. As you note, there are agencies that have the authority to proceed both administratively and in the courts. I think you noted like the CFPB is one of those. It had recently issued a rule suggesting that it was maybe going to move more towards administrative adjudication, but it historically has not done so. It's historically proceeded in court. So we'll have to see what comes out of the government on that. But I think it's my guess is it's more likely to arise in the context of defenses to administrative actions. you know, no one wants to sort of pop their head up against the government unless they're really sure the government's coming after them. It's just not a good strategy. So I think that is the case. Now, I think it will be interesting to see whether parties who are the subject of administrative enforcement always decide they want to raise this argument or not. While I flagged an issue in the consent piece, like even if it were true that you cannot consent to the violation of Article 3 by like adjudication of a private right in an administrative forum, it's also the case that party presentation matters. This is not like subject matter jurisdiction where they're going to have to like sua sponte raise it. So if a business or person decides they don't want to raise it, they want to proceed in the administrative adjudication process because they think it's more efficient, lower cost, whatever, they can certainly do so and just not raise the Seventh Amendment or Article 3 arguments. So I think we will continue to see some people raise this in the defensive posture. I think some may decide not to raise it. I think whether that decision, that sort of strategic decision not to raise it, is more likely in the context of an agency that could also proceed in court, right? If it's an agency that can only proceed against you administratively, so then your choice is, I'm either going to proceed with you administratively, or maybe I'm going to get out of this entirely because you're going to lack the authority to come after me for civil penalties. Then the incentives are different, right? For the person who's the subject of administrative enforcement, it's not a case of, am I going to be in court or am I going to be in the agency? It's a case of, am I going to be in the agency or are you going to be stymied? But I think more likely in the defensive posture, it's of course possible, especially if there are, roving investigations of things that would only lead to civil penalties. We could see more affirmative action like in Axon versus FTC. But I think that remains to be seen.
That's terrific. And we will come back in a few minutes to your suggestion that some respondents may want to stay before the agency, and that goes to Chris's article on the removal power. But before we do that, let me just turn to Chris, and then I'll turn to Jeff. As a practical matter, what is the landscape going to look like post Jarkesy? Where are we going to see the challenges? How many challenges are we going to see, and so forth?
I still want to get to the waiver point, but I'll resist. I think
talk about the waiver issue if you'd like, and how that how waiver and the Article 3, how Article 3 differs in that respect.
Yeah, I do think so. I'll hit the waiver point because I do think in a system where parties have the right to remove from adjudication, I do think you are going to see a lot of parties stay in the adjudication for the reason Jen mentions. Also, most of these cases settle pretty early, and settlement will be pushed before you move to into an Article 3 court. And with the jury question, that's like no one debates you can't waive your jury right. I mean, that's easy. The Article 3 question, especially after Wellness International, is harder. I think the Chief Justice is wrong. I think Alito's entirely right. Of course, we have private arbitration over issues that. And I think it's just a similar kind of approach, is that you should be able to have a right to consent to have an adjudication done outside of an Article 3 court, whether that's a private arbitrator or that's a government arbitrator. That's your right. And I hope that the Chief Justice kind of rethinks that, because I don't agree with Jen on this front. If you don't have a right to remove, no agency is going to set up an adjudication system and give you the option to have an agency adjudication saying, well, as long as you don't raise it, no, it's not how agencies aren't going to structure that way. In fact, the SEC is a good example of that. They've already stopped doing almost all adjudications before the agency originally because of litigation risk of Jarkesy. And I think now because of Jarkesy itself. And so I think that right to remove is really important. But I do agree that at least the Chief Justice's approach in Wellness International could be a barrier to that. I hope he reads his former law clerk, Will Bode's article, because I think Will's entirely right about the idea that you can consent to adjudication outside of Article 3. Okay.
Jeff, do you have any thoughts on, as a practical matter, what types of adjudications and which agencies we're likely to see challenges? I know that I'm asking you to look into a crystal ball, and the answer maybe it's sort of impossible to answer the question.
I think any respondent in a future administrative civil money penalty case is going to raise a Jarkesy challenge, and see what happens. So there's going to be a lot of litigation in the lower courts about this, for sure. Now,
And so, go ahead, I'm sorry.
and what about license revocation cases and these other types of enforcement cases that agencies can bring? Would an agency that's faced with having to go to federal district court in a jury trial for a civil penalty decide, well, we might as well send it over to DOJ for a criminal penalty if we're going to have to do that for a civil penalty? It might undermine agencies' interest in using civil money penalties, and that they can if their statute gives them the authority to use disgorgement or debarment or license revocation, then maybe they'll do that and argue that those are equitable remedies. Cease and desist orders, they seem to be equitable remedies. But again, I'm not a remedies teacher, so I don't know where the line really is between law and equity. I thought we abolished that distinction in American law anyway.
Well, remedies law didn't abolish it. We procedurally we abolished it with the merger. But let me turn quickly to our next question, which is something that both Jen and Chris alluded to some extent. But how will federal agencies respond to Jarkesy? Let's start with Jeff. Why don't we start with why don't we go Chris, Jen, and then Jeff on this one?
Sorry. Oh, sorry. Can you repeat that real quick?
The basic question: how will federal agencies respond to Jarkesy? Will they stay their hands in some cases, in effect, sort of suspend their adjudication programs and so forth and so on?
Yeah, I think once we start seeing litigation coming down the pike, I think you're going to start seeing agencies proactively, like the SEC did, shift to the extent they can to Article 3 courts, or as Jeff mentioned, to equitable remedies and away from civil penalties. I would expect that. I still keep on hoping that they'll just create a right to remove through a procedural rule. And at least let's try that out. But for now, I think that's what's going to go on. And Congress could also get involved, right? That's another option that we like.
Yeah, we'll turn to Congress in a second, but why don't you just explain in a nutshell your proposal that an agency could create a sort of a removal right through administratively through a rule.
Yeah,
rather than asking Congress for a statute.
Yeah, and just tomorrow the SEC could issue a procedural rule that says, well, whenever we anticipate potentially seeking civil penalties, we will let the party know, as they already do, that we're going to seek civil penalties, and you have 30 days to say we'd rather have this in an Article 3 court before a jury. And if you don't say that, then you're saying your consent to be before the agency. And that doesn't really require notice of comment rulemaking. It's a procedural rule. It's an additional procedural path they have. And at least with respect to the civil jury trial, that's like easy. With respect to the Article 3 form, I think there are different justices with different approaches on whether that can be waivable. But that's the basic idea that you'd have, is that the agency gives the party notice, so that then the party has a certain amount of time to do this. Congress has actually enacted this several times already in other agency contexts where they give the right to remove. The U.S. Chamber for over a decade has advocated for this. And so is the ABA Administrative Law section. It's a lot older, the ABA Business Law section back in, I think in the 80s also, or 90s also really advocated for Congress to recognize this right to remove. So that's kind of the idea. And I think one of the big benefits of it is, well, obviously it allows for parties to stay in agency adjudication if they want to. It also, though, allows for, a lot of these cases are, it encourages agencies to develop more expertise and to be more competitive with Article 3 courts when it comes to how quickly they resolve matters, their discovery procedures and the like. So that's kind of our pitch for what they do and why tomorrow the agency could just create it through a procedural rule.
Jen, agency responses to Jarkesy, whether with respect to Chris's removal by rule proposal approach or otherwise?
Well, I assume the removal by rule approach would apply to agencies where Congress has already authorized them to proceed in court. So that wouldn't solve the problem for agencies that lack that authority. I would expect that agencies will initially be thinking, okay, what are we going to do for our existing adjudications that are already in place? Whether the Jarkesy issue has been raised there or not. There's all sorts of issues there with party forfeiture. And maybe they're just going to try to settle those cases. Maybe they realize that their hand is perhaps not as strong as it once was. So a favorable settlement rather than losing all the momentum of that adjudication is better. I'm not sure. But they have to address those. Then they have to decide, do we want to hold on pursuing any new adjudications until we've kind of figured out our policy going forward. Then they have to evaluate their rules, their in-house rules that govern when they seek to go into court versus, proceed administratively. A lot of agencies, there's internal operating procedures, not like external facing rules, but they'll have to evaluate that before they sort of start moving differently. But I think they're going to have to evaluate all three sort of buckets and then decide how they want to proceed. I would expect that we'll see an uptick in actions filed in court just because it at least avoids the problem. But there's a lot to be done. And they have to assess, it's not just okay, every time we seek civil penalties, they also have to say, well, if we're seeking civil penalties, is all of this in the private rights bucket, or is it some of it still in the public rights bucket after Jarkesy? And I would expect them to consult with not only theirs, but DOJ on that, trying to figure out the scope of Jarkesy, because they're not going to want to apply Jarkesy to everything if they don't necessarily have to. And as we said, there's a lot of sort of open water around how broad the public rights exception is going to be going forward.
So let me just, before I turn to Jeff, and we will come back, and I think we'll end with possible congressional responses or likely congressional responses. But let me just, you raised the question that you raised an issue that I did want to touch upon, and let's just bring it into play now, which is, do we expect should agencies expect, including agencies that have independent litigating authority, not just those who rely on the Department of Justice, but should agencies, do you think, expect some kind of guidance from the Department of Justice of the sort that they've gotten after other Supreme Court cases in the administrative law area, like the Lucia case dealing with the officer status of ALJs? Do you anticipate? I'll turn to you first, Jen. I mean, I know you don't have the inside knowledge here, but do you expect DOJ to issue any guidance for agencies?
I do. I would expect that they would issue some guidance on how to deal with their existing things, how broadly to interpret public-private rights. If I were at DOJ, I would say, here's how we read it. Call us with specific questions. We will help you work through this, because they want to have as coordinated a position as possible going forward. And this is going to be the subject of a lot of litigation. So I would expect some rapid advice from the Department of Justice and an ongoing process, potentially with OLC involved, about the public-private rights distinction.
Okay, and before I turn to Jeff on the question of how will agencies respond if he wants to address that, let me just ask Chris and Jeff, do you have any other thoughts on DOJ guidance to agencies?
I just say I'm kind of surprised they haven't issued guidance yet. I mean, this is something where I would have thought, especially since they have litigating authority over so many of these issues, I would have thought they'd already jumped in the game. But I'm sure that should be coming pretty soon.
Yeah,
I have no doubt they've issued informal guidance, but I'm actually surprised they didn't do like they did after Lucia, where they kind of came forward and kind of gave a roadmap going forward.
Right.
Maybe they haven't done it because it's too hard to draft right now. I'm waiting to see what some of the litigation, how the litigation comes out before they. And so I think when Jen says it's going to be ongoing, they're going to have to be monitoring future case decisions pretty closely. But I want to emphasize that there are only 3 or 4 agencies that have the choice of going to court or to the administrative adjudication forum. Most of the agencies have one or the other. And the ones that have administrative adjudication authority, if their cases are covered by Jarkesy, then what do? Congress is going to have to change their statutes to allow them to go to court
Well, let's
in
come
the
back
first
to that.
place.
Let's come back to that last. Anything else on the agency responses?
It might depend on whether they have independent litigating authority.
All right, so let's turn to this as the final question, and then we'll take a look at what's in the chat in terms of audience questions. I'll start with you, Jeff. How can Congress respond to Jarkesy? You mentioned obviously authorizing federal court enforcement to collect civil penalties. I mean, among other things, how likely a possibility is that the Congress will actually, the Congress these days will actually provide that enforcement authority?
I mean, it's hard to get Congress to do anything these days, but if the Republican half of Congress can be persuaded that they're sort of implementing Jarkesy, by passing legislation that transfers the agency's authority from the administrative adjudication forum to the court, then maybe enough of them can pass it to keep the agency's enforcement program alive. But it's going to be dicey, I think.
Chris, on the Congress, how can Congress respond, and how is it likely to respond, if at all? And then the same question to Jen.
Yeah, I mean, it's not like there's like an APA of civil penalties. I mean, like these are all, agency by agency. And so you're going to see different committees with different cultures that approach this differently through reauthorization or the like. I think the two,
except for that program civil remedies statute,
Yeah.
which is a government-wide statute.
Oh, I guess that's right. I mean, I guess that's one way you could approach it. But I mean, I think the best arguments would be what Jeff mentioned earlier. Our agency is going to get more creative and use equitable, more punitive type approaches. Hey, Congress, like we should authorize courts to do this now, because otherwise the agency is going to be able to use other tools that are worse. And then the other one is the right to remove is something that Congress, I mean, it's got bipartisan support, and that's something that Congress could do now. And I think that's probably a little bit lighter lift, especially if it's agency by agency, not some kind of grand one. Although, Jeff, I've got to think more about your point about kind of the larger statute. I'd always thought of this as much more of an agency by agency. And I'm kind of hopeful it might happen in that context with respect to some agencies, just the way that committees are structured with respect to reauthorization and appropriations.
Jen, the congressional response, if at all?
I don't think I have anything to add. I think Jeff and Chris covered the water on that.
Can I just say one more thing before we can? Well, it's sort of a little bit ironic here. We're talking so glowingly about the right to a trial by jury in a way, because, yes, it's in the Seventh Amendment, it's in the Bill of Rights, but it's the one right that has not been incorporated, or one of the few that has not been applied to the states. And, we're the only country in the world, basically, that uses juries for civil trials. England used it for some, a few cases still, but they abolished most of their civil juries and civil trials. So, there's been a lot of criticism of using juries in complicated antitrust types of cases and that sort of thing too. So, if we take a real step back, how much do we want to push jury trials in civil cases?
We have about 10 minutes left. There are some questions, or in many cases, comments among the questions. A lot of these questions, as I read them, go to the issue that we discussed earlier, which is how do you categorize various types of cases with respect to the public rights category, and I don't know if any of the panel have any of the panelists had an opportunity to look at these questions, look at any of the questions, and see if are there any of them we should address because we haven't already addressed them. Some of them are very particular, and we may not want to get into all of them. But are there any questions here that anybody sees as standing out in terms of raising issues that we haven't already addressed. Again, a lot of them go to the question of how should this particular type of adjudication be categorized with respect to the public-private divide. Anyone? You take a quick look.
Well, one question is, why didn't the court address some of the other SEC remedies in the Jarkesy case itself, like ordering Patriot 28 to disgorge earnings and debarring Jarkesy from the securities industry? What do you make of the court not addressing those other remedies?
Chris or Jen, do you want to take that? I mean, the answer could simply be the court didn't, grant cert on those questions. They weren't raised. I don't recall whether they were raised in the Fifth Circuit, but do you have any thoughts on that question that Jeff just relayed from one of the attendees?
I mean, I think it's just what you said. They granted cert on the Seventh Amendment civil penalties question. That's what they were focused on. The court tries not to wade in on other things that aren't like squarely presented in the question presented if they can avoid it.
So the Fifth Circuit will still have to decide that?
I don't know if Jarkesy, like if they've raised it in the same way for like a Seventh Amendment. I don't know what the status is for a remand on that.
It's been a while since I read that. I read all the Fifth Circuit briefing, and I don't think Jarkesy raised any types of arguments along those lines in the Fifth Circuit. It was focused on the dual layer removal and the Seventh Amendment issue, and then the non-delegation one kind of got created during oral argument. Like, that's not really even in the briefing. I don't think they're talking. They're just really focused on the civil penalty, nothing else.
But if the ALJ ordered debarment and disgorgement, then the ALJ, if the ALJ is unconstitutional, then those would go away too.
Yeah, which is the weird thing of this case, right?
Yeah.
By the court saying we're not reaching these other two questions, they did not vacate them. And I don't know what the case is doing on remand now, but
why don't we do this, Chris? No, go ahead. Please finish. I'm sorry.
I'm done. Yeah.
Well, I get the sense that at least you and Jeff are eager to briefly talk about the for cause issue. Why don't we turn to that in the time remaining, rather than trying to figure out now what's in the public rights bucket and what's not, which is what a lot of these questions do go to. And frankly, I don't think any of us know the answer to that at this point. Chris, could you just in a nutshell explain what this for cause, this or dual for cause protection is, why the court didn't address it, and where does that leave all of us and agencies in particular where does it leave them without an answer from the court on a question that will continue to be litigated?
Yeah, I mean, so this question affects every single administrative law judge in the federal administrative judiciary, which is around 2,000 judges. It arguably also affects every administrative judge that has civil service protections, but we'll leave that for another day. And it comes from a case called Free Enterprise Fund, where the Supreme Court said you had this kind of weird agency structure where the Public Company Accounting Oversight Board was nestled within the SEC, and both the heads of the PCOB had for cause removal protections in the statute, and the heads of the SEC, everyone conceded, had for cause removal protections. And Chief Justice Roberts, writing for the court, said you can't have dual layer removal protections. That separates the officer too much from the president. Justice Breyer in dissent said, whoa, wait a minute. Among many other things, this is going to completely blow up the administrative judiciary, because administrative law judges have for cause removal protections, and so do the head of the Merit Systems Protection Board. And at independent agencies like the SEC, you have actually 3 layers of removal protection, because the SEC commissioners, at least we all concede that they have them. I mean, that's probably a whole nother webinar. So that issue has been raised in a number of different cases across the country. And in Jarkesy, the Fifth Circuit said what I think is obvious from the formal structure of Free Enterprise Fund, that dual layer removal protection for the administrative law judges are unconstitutional. And that question wasn't obviously answered by the Supreme Court. I think one question was asked or argument about it. But the weird quirk is the Fifth Circuit's decision saying it is unconstitutional was not vacated on that issue. And so at least in the Fifth Circuit, when it comes to SEC ALJs, I think the dual lay removal is unconstitutional. Now, what's the remedy? I would think the remedy would be to take away the for-cause removal protections for the heads of the agency, both the MSPB and the SEC. The Solicitor General in her briefing, though, argued that the administrative law judges shouldn't have for-cause removal, that they should be removable at will if they lose on the merits. And if you've talked to an administrative law judge in the last 20 years, they will all tell you that that would be like the end of agency adjudication, because administrative law judges would now be fearing that they'd be fired or otherwise punished if they don't rule in a way that aligns with the politics of the agency head. So that's kind of the issue that's going on the dual layer removal. I think there's already one other case done with SpaceX where a court has found the dual layer removal to be unconstitutional. So it's going to make its way back up to the court very soon. A very short version is, I think there are arguments that adjudication is different and that the formal logic of free enterprise extend to agency adjudicators. I'm not sure the court, because they are so formalist in the separation of powers area, is going to be able to actually, grab onto that difference.
But
Yeah,
look at footnote 10 in the free enterprise fund case.
Yeah, Jeff is referring to footnote 10, where the Supreme Court reserved decision on the application of the free enterprise fund principle to administrative law judges, and also reserved decision, if I think in that footnote, on the status of the civil service more generally, which has for-cause protection. Generally, I think, Chris, you're referring. I think there was a SpaceX decision the other day. I think it was a preliminary injunction decision out of maybe the Western District of Texas. There may also be I don't know this, one of the ACUS folks would probably know this. There may be a Ninth Circuit case in opposition to the Fifth Circuit case, but I'm not in opposition to the Fifth Circuit decision in Jarkesy. I'm not entirely sure of that. Before I just turn to others, let me just point out that 3 ACUS members, Alan Morrison, Ron Levin, and Dick Pierce, I believe, did file a brief in Jarkesy saying to the court, if you're going to take out somebody's for-cause removal protection, take out the agency's heads removal rather than the ALJ's for-cause protection. So anyway, that's an interesting issue you brought up. Let me before I turn to Jeff and Jen to conclude on this particular issue, what would be your prediction if the court is presented with this issue of the constitutionality of these double for-cause or triple for-cause arrangements in the case of ALJs? What is it likely to do?
I think it's going to say that the heads of the agencies, I think it's say dual layer removal is not constitutionally permissible, and the remedy is going to be to overrule Humphrey's executor. I think that's where we're going. I hope that's, if the court does reach the merits that way, I hope that is the remedy, because I do think it would be really awful for agency adjudication if adjudicators are removable at will.
Jan, what are your thoughts on this, very briefly, and then Jeff, very briefly?
I don't know what remedy they would pick. I do suspect that under the reasoning of PCAOB, they would find the dual layer problematic for ALJs.
And Jeff, you're hanging your hat on footnote 10, is that right?
Yes, and also the fact that the Supreme Court has upheld the ALJ program as a whole in the past, and they've also upheld many decisions issued by ALJs in the past. So it would be a pretty big jump to say that ALJ's independence should be removed. And given the fact that the Humphreys executor issue is going to come up squarely anyway, because there are other cases just raising that issue coming from the Fifth Circuit, that I think it's more likely that the agency head's independence would be removed than the ALJ's.
Well, thank you all very much. This brings us to our stopping point here. I want to thank all the panelists on behalf of ACUS, if I may, for joining us today, and more importantly, or just as importantly, I should say, all of the many attendees for joining us this afternoon. Thank you very much.